Kia ora koutou. Good morning, everybody. I'll start again for the recording. Good morning, everybody. Welcome to what's our final day of hearing 18 rural. We've got some submitters to hear today. I don't think we need to go through any of the background information. The only thing I just want to mention is something I mentioned at the start of the hearing, but I'll mention it again now for the sake of completeness, is that the panel has a register of interests whereby it discloses any known or perceived conflicts of interest. And in relation to Bathurst Resources submission, I won't take any part in hearing or deliberating on their submission, given my firm's relationship with that company. I think we've got a few new faces at the virtual table today, and there's not a huge number of people here. So for those people that haven't been involved in hearing 18 until this point, if you could just quickly identify yourselves, please, just so that we can see who's who in the room. And I'm happy, maybe the panel should do likewise, given that there are such a number of new faces. Phil Mitchell's my name. I'm chairing these hearings.
Good morning, I'm Diane Fulton. I'm a former councillor and independent commissioner.
Morning, koutou, Will Marg, independent commissioner.
And good morning, Janet Gibb, a current councillor and independent commissioner.
Paul Cooney, lawyer, commissioner.
Good morning, Josh Licky, councillor for Bathurst and BT Mining, and with me virtually today I've got Craig Pilcher, who I'll let him introduce himself, and also Alison Brown, both from Bathurst and BT.
Got it.
Thank you very much.
Right, Craig Pilcher, General Manager, Domestic Operations for Bathurst Resources. I run the two mines down in the South Island and Rowe and Maramura.
Thanks, Mr. Pilcher. Welcome.
And I'm Alison Brown. I'm General Counsel for Bathurst Resources and BT Mining Limited.
Thanks, Ms. Brown. Good morning.
Morning, I'm Kelsey Barry. I am here with Ken Barry, who is my father, and we are... I'm sorry, can you hear me?
Yes, we can.
Yes. Sorry. Yes, so I'm here presenting with my father, Ken Barry, and I will also be observing the Bathurst Resources Limited.
Thank you very much.
And I'm Ken Barry at Ragland, representing myself.
Welcome, Mr. Barry. Looks like you're keen to say something, Dr. Forrett, but aren't.
Oh, Commissioner, I'm not. Good morning, Commissioner.
We're going now.
Panel. Wasn't sure whether you were wanting all of the participants that are involved in the other subsequent matters as well, or just the Bathurst to begin with.
No, sorry, no, everybody. I'm sorry. I was just declaring my interest and then was going around the room. So.
Oh, well, on that basis, Joan Forrett, counsel for the Combined Poultry Industry Group and also for Lochiel Farmlands Limited, and I have with me in my office Pavinda Kaur, who's assisting me, and Kim Robinson, who is the General Manager for Lochiel, and virtually we have Michael Brooks. Michael can introduce himself.
Good morning, I'm Michael Brooks. I'm the Executive Director of the Poultry Industry Association and the Egg Producers Federation of New Zealand.
Thank you, Mr. Brooks. We've got a council team comprising Mr. Cleese, Ms. Overwater, Mr. Bell, who's our administrator. I think that's all that we can see on the screen. I think we can take those folk as read, no disrespect intended, but they've been at the hearings throughout. I think Mr. Finlay is there as well, if I'm not mistaken.
Yes, I am. I had a bit of trouble with my audio, sorry, at the start, so I can hear you all. Thank you.
That's fine. That's we can. And there's also Mr. Rowe, I can see there. Not sure, Mr. Rowe may. Oh, there he is. He's just come online, I think.
I'm just viewing today. I've got nothing further to add.
All right, thank you. Yeah. And Ms. Deverell, who we heard from yesterday. So there's also Mr. Gauntlet and Ms. Ratt there involved with the council side of things. So I think without further ado, we'll pass over to you, Ms. Barry and Mr. Barry, and hear your presentation to us. Just for the sake of completeness, we have read all the evidence. We have read the legal submissions that have been provided where they have been provided. And the way that we're running these hearings is to request highlights packages. Reading vast tracts of material that we've pre-read isn't particularly helpful to us. We're very keen for people to focus on what the issues of concern that are outstanding are, and more importantly, or equally importantly, what they want us to do about those matters. So we would just seek your cooperation in that regard. And I think without further ado, we're ready to kick off. Thank you, Ms. Barry.
Okay. Good morning, commissioners and parties. As I said, I am here assisting my father. I'm assisting in a quasi-legal capacity, so I haven't filed formal legal submissions, but I did just want to make a couple of high-level legal points prior to Dad giving a summary of his evidence.
All right, thank you.
The panel will be well aware of the statutory and planning context, and I've reviewed the opening submissions by the council, and I don't have anything further to add in that regard. What I would really like to focus in on is the Waikato Regional Policy Statement. For those parties who aren't aware, my father's submission is based around the high class soils and the prohibited activity status rule for subdivision in those high class soils. So Ms. Overwater acknowledges that the application of the Waikato Regional Policy Statement to the high class soils in the Waikato district, and she refers to the strong policy framework for high class soils provided both in the Waikato Regional Policy Statement and the proposed National Policy Statement on highly productive land. And my main submission point around that is that although there may be a strong framework in that regard, those documents are not promoting a prohibited activity status. The NPS, or proposed NPS, on highly productive land, although not of any legal effect yet, it is worthwhile noting that both the summary for that document and the discussion document expressly refer to not promoting prohibited activity status for subdivision on high class soils. Similarly, the Waikato Regional Policy Statement seeks to protect high class soils from inappropriate subdivision, and I think that that is quite an important indicator that some subdivision in high class soils may in certain circumstances be appropriate. Obviously I acknowledge that lower order documents like district plans are entitled to make more restrictive rules than the higher order documents. But in my submission, the proposed plan must still give effect to the Waikato RPS under section 75(3) of the RMA and a prohibited activity status, which completely stifles development for post-December 1997 titles, does not give effect to the requirement to protect high-class soils from inappropriate subdivision. The rule assumes, one, that the properties assessed as high-class soils, which I understand have been assessed on a desktop basis, are in fact high-class soils that are capable of being used for productive rural activities, and two, that subdivision post-December 1997 is inappropriate because it constitutes double dipping. I'm unsure what the resource management effect, what the additional resource management effect of double dipping is compared to pre-December 1997 title subdivision. In terms of the accuracy of the Council's information as to high-class soils, DAD's evidence has demonstrated why high-class soils, categorised as land use capability classes 1, 2, and some of class 3, are not always workable for productive rural activity. Or if they are utilised in that way, in a rural productive sort of pastoral type manner, they can create adverse environmental effects. This is particularly evident on my father's farm, where there is erosion given the hill country nature of the farm. So the proposed MPS on highly productive land acknowledges that the land use capability classes are not the only means of ascertaining whether land is suitable for primary production. If enacted, the MPS will require district and regional councils to consider land, consider the criteria in the NPS in addition to those land use capability classes. Some of that criteria includes the sizes of the blocks, access to water and infrastructure like roading, and anything that would prevent the land being utilised for productive use, such as erosion. The other point that I wanted to make was that the mapping of the land use capability classes, which I have to say I actually found quite difficult to navigate, is at a scale of 1 to 50,000. So on a farm like my father's, which is 40 hectares, it may be that the mapping on a scale of 1 to 50,000 is actually not quite accurate. And without the ability to apply for resource consent, landowners essentially lose the ability to provide site-specific soil assessment as to whether their land is in fact high-class soil. And so for that reason, I think that prohibited activity status is inappropriate, because the information that it's being based on may not be accurate, and it's not allowing landowners the opportunity to actually assess that. Presumably the other way would be that they get a soil assessment undertaken and perhaps present that to the regional council, but it seems to me that it would be much better that it be done as part of the resource consent.
I was just going to ask you that, Ms. Barry, but my understanding at least is that the district plan proposed has a definition of what a high-class soil is by reference to soil class, but doesn't attempt to spatially map them at all.
Yes.
The maps that you're referring to are, I think everyone would acknowledge, are broad-scale land use capability maps.
Yes.
And if your father or any other landowner had a soil survey done on their farm that said it's actually not this particular class, it's some other class, that prohibition would no longer apply, would it?
No, it wouldn't, because the prohibition is, like you say, it is specifically related to high-class soils. The issue, and yes, that's absolutely correct. The one issue that I see with that, though, is that the land use capability assessments, from what I understand, are specifically based on the type and quality of soils. So, for instance, I think part or maybe all of
Yes.
alluvial soils, and I think that's
Yes.
under category 3, but it doesn't take into consideration those other factors, for instance, likelihood of erosion, the size of the block being able to be utilised for productive land use and that sort of thing. Those
Okay.
aren't in the specific soil.
I understand the point you're making. Thank you.
I think that that's probably all from me. So I suppose by way of very brief summary, the application of a prohibited activity status rule when the information regarding high class soils may not be accurate and is not easily available to submitters does not give effect to the Waikato Regional Policy Statement, because it does not allow the assessment to determine whether or not the subdivision is actually inappropriate. And so on that basis, I'll hand over to Dad to give a bit more factual evidence.
Thanks, Ms. Barry. Welcome, Mr. Barry. Just when you're ready, as we've said, we don't need you to read your evidence from start to finish. We have read it. So why don't you explain to us your particular circumstances and what you're seeking, please?
Yeah, my circumstances are that it's only a small block, and with trying to come into focus with what District Council's proposing with changing my rural zoning from coastal. I'm only 400 or 500 metres from the Rowe Bay Harbour, and I have actually a hilly block running right through the middle of it, and a lot of that land with the new resource situations coming on and what you can actually do on it needs to be planted out, and I'm not a pine man. I'd rather put it into natives than actually look after it a lot better. I've seen the damage that pines do, and just permanently put it into good native and manuka and stuff, fence it all off, and you know, do beehives. It's only a little block. I'm in the mid-60s. It's a few sections in a nutshell would help me actually achieve all this. And on the clauses that they've got, then you know, that they've got in there, I'm going to miss out. And that's pretty much it.
Okay, you've done a lot better than some of our professional witnesses in summarising what they want, Mr. Barry, so thank you for that. Having said that, your evidence is detailed and we have read it, and we certainly appreciate there's a lot more to the points that you're making than the brief summary you've given, but we're grateful for the quality of the information that you've provided us. Let's see if there's any questions of you. Can I start with you, Mr. Marg, please?
Yeah, good morning, Mr. Barry. Just to be clear, the desktop analysis that your daughter referred to, if indeed there was an actual analysis on whether it is high-class soils, that would change the definition as it is. But right here, right now, everything's reliant on a desktop analysis. Is that correct?
I believe so, you know, but if you can't ride a motorbike over it, or you can't walk up it hardly, I don't think that qualifies as high class soils.
Yes, yes.
As a farmer who's 30 years.
Totally understand what you're saying.
Thank you, Mr. Marg. Ms. Gibb?
Yes, thank you for your presentation, both of you. It was very clear. So I do understand the dilemma you're in, and so Ms. Barry, are you suggesting that this should be restricted, discretionary or non-complying instead of prohibited? What are you suggesting?
I think that non-complying would probably be more appropriate than restricted discretionary. I do think, and I do certainly understand the intent behind wanting to protect high-class soils and stop fragmentation of high-class soils in the Waikato. But I believe that a non-complying activity status, it will give landowners like my father an opportunity to at least put their case forward and see whether or not they can have some really great outcomes through funding from subdivision. And it will also have the extra, the section, is it 104.2, I think, the extra analysis as to whether it does not have adverse effects that are more than minor, and that it is consistent with the objectives and the policies of the plan. So it does have that extra gateway threshold test to ensure that, you know, it is a sustainable outcome in terms of the RMA. I think something like restricted discretionary is probably, it makes it too easy and it doesn't give the protection that the council is looking for.
Okay, thank you. And just one more question. Do you already have native planting on the property, and is it designated, or have you had advice from the council that it's an SNA, or if there's any significant natural areas on your property at all?
Yeah, so there is one significant natural area. So when Dad did a previous subdivision, he gifted a portion, and Dad, you might be able to give a bit more information about the bush behind the house. He gifted a portion to, I think it's the QE2 Trust.
QE2 Trust, paragraph 8 of the evidence. I'm just reading it again now.
Yeah, and
okay.
so and
Two areas gifted by the look of things.
All right, that's good, that's clear. Thank you very much.
Thank you, Ms. Gibb. Mr. Fulton.
Yeah, no, I have no questions. Thank you, Mr. Barry.
Mr. Cooney.
Just have you engaged a soil scientist to check the status of your land at all?
I don't think.
No, I haven't.
Sorry, you're breaking up.
Sorry. Yeah, no, I have not envisioned. CKL did my subdivision back in 2002, I think it was, and they told me that I would have to go to regional council and spend 20 grand to get the high quality soils taken off my title, off my, you know, whatever zoning, if you like.
Oh, okay. Okay. Yeah, that seems extraordinarily high. But anyhow, thank you. And thanks, Ms. Barry, for the way you presented the case on behalf of your father. Just an aside, are you going to send him a bill?
No, that was I think there was a little bit of confusion at the start because I've been assisting Joshua Leckie a little bit as well, and so I need to make it very clear I'm a legally minded lay witness. I am not acting as legal counsel.
Okay, thank you.
I've just got a couple of questions for you, probably best addressed to you, Ms. Barry. I think there's two different issues at play in relation to your father's submission. The first one is the high class soils issue, and the second one is the date of which the existing subdivision was undertaken. So you've sort of got two conflicting issues, if you like. I've already asked you about the high class soils aspect, but if there was provision in the plan that said, well, no, I'll go back one step. Have you had a look at the section 42A recommendation for conservation lot creation in relation to restoration or enhancement planting?
No, I actually hadn't read that part of the section 40.
Because I'd suggest that you do, because one thing that is a discretionary activity, and this is putting the high class soils issue to one side, that talks about subdivision potential where someone is looking to enhance or expand an existing SNA as defined. And it seems that you're in that category already. You might just want to have a look at that. And because apart from the date issue, and which I understand the point you're making around that, but it may be that where it's blindingly obvious, and I'm not saying this is the case because we need to deliberate, that a piece of land is not appropriate, but it does have huge conservation potential, and the reason that it's not being realised is because of funding, because there's nothing to stop your father doing all the conservation work. The problem he has is that he's got to pay for it somehow. But you might want to have a look at, and I'll just leave it at that restoration or enhancement planting rule that the staff have proposed, because it may go some way with some tweaking to addressing the sort of issue that you're raising.
Great, thank you.
Which is more a statement than a question, but it started off with a question that said, had you read it? You said no, so I drew it to your attention.
Thank you very much.
All right, I don't think we have any more questions. Thank you both very much for your evidence and submissions, which brings us to Bathurst Resources, which I will absent myself from. I'll just mute myself, turn my volume off, and turn the video off. So I'll be back in due course. Leave you with Mr. Cooney.
Right, thank you. Mr. Leakey.
Thank you, Commissioner. As I mentioned earlier, I'm here virtually with Mr. Pilcher, who has given evidence. Mr. Pilcher is available for any questions, obviously, as well. And we've got Alison Brown here, legal counsel for Bathurst, and prior to that, Solid Energy. So arguably has an equally long involvement in the mining industry as Mr. Pilcher. Now, I've filed relatively lengthy legal submissions, which I'm not proposing to read.
Good.
Rather than that, I'll touch on the key points, but if I move too quickly or too slowly, please just let me know.
No, that's fine. That's fine. If you can just summarise them, and when you get to the end, could things have moved on a little bit with the 42A rebuttal report coming through and granting you some of the relief. So if you could just summarise what other relief you are seeking, and just point to us what we've agreed to,
Yes.
then that'll help us. You'll appreciate that we get we read all this evidence, and then we get so many submissions, you tend to sort of lose the actual, what the relief you're actually seeking. So if you can do that, that'd be good.
Absolutely, I appreciate that. There's a huge volume of material just for this topic, which I appreciate. It's only one that you're considering. So I'll do that. And the good news, I guess, to start, is that there is a lot of alignment as between Mr. Cleese's rebuttal position and that of Bathurst BT, which does simplify the submission somewhat. But just initially for background, I'll refer to Bathurst and BT relatively interchangeably. Bathurst technically is the operator of the mines, whereas BT, which is a joint venture between Bathurst and Tallies, they are the permit holder. But for the purposes of the presentation, we refer to them relatively generally. Mr. Pilcher has some maps attached to his evidence, which I suggest are a good way to orientate the discussion that's going to follow, in particular Annexure E, which includes in a graphical sense the assets, the mining assets that we're talking about, and the coal resource.
Do you want to put those up on the screen?
That will probably throw my technical ability, sorry.
Fletcher, are you able to do that?
So it's Annexure E to Mr. Pilcher's evidence.
Yeah, it'll just take me just a bit to find it.
Okay.
Thanks. I'll start giving a high-level summary, and I can talk to the plans when they pop up on the screen. But the 30-second snapshot of the relief being sought by Bathurst BT in this case is twofold. In our submission, there's a lack of enablement of existing legally authorised coal mines in the Waikato district, and also their logical and I'd argue efficient expansion. Now, this is a point I've explored informally with Mr. Cleese, and there's not much of a gap from my perspective, in terms between the council and Bathurst on this. This is a recognition through the coal mine policy area of these existing mining operations. The second theme of relief relates to the identification of the coal resource itself, so separate to the current operations, and that the second theme is where there's more of a difference of opinion between Bathurst and Mr. Cleese. Mr. Pilcher's evidence has given a summary of the history of coal in the Waikato right back to 1876, and to move to today, from Bathurst BT's perspective, there's essentially three key current mines or operations. There's the Rotowaro mine, the Maramarua mine, and what's commonly referred to as the Huntly West mine, which is more of a coal handling, coal stockpiling facility at Huntly. And they're shown in Annexure E of Mr. Pilcher's evidence. Just in terms of scale, the Rotowaro mine currently produces around 550,000 tonnes of coal annually. Maramarua, more like 250,000 tonnes of coal. And together they contribute around 67.8 million to the Waikato district economy each year. And this is acknowledged in the proposed district plan. In terms of the coal mapping, there's been significant mapping of coal across New Zealand.
Can you see that, Mr. Leakey?
Yeah, that's helpful. So that's what I'm talking to there.
Can you bring it up a bit, Fletcher? Can you just make it bigger? Yep, that's fine. Okay.
Great. Thank you for that. So you'll see there Maramarua with the coal mining, the coal mining area shown in a red outline. Further down the page is what's referred to as West Mine, which is the coal stockpiling operation at Huntly, and then the larger mine at the bottom of the page, Rotowaro. So those mines being shown and operations being shown in red. Just for context, well, Mr. Fletcher's got the map up there. The yellow shading is the mapped coal resource based on reputable government mapping, most recently is 2019. And it's this mapping that I refer to further on in the submission. But if we could just leave that up, it orientates the discussion to follow. So the submission of Bathurst is that there's a need for ongoing coal, both in the Waikato and New Zealand more generally. And Mr. Pilcher's evidence has summarised this, the key customers in the Waikato area being Genesis Energy, which most people will be familiar with, the Huntly Power Station, New Zealand Steel being the Glenbrook Steel Mill, and also several dairy factories in the Waikato that are currently fuelled by coal. And more recently, like this hearing, the country was affected by COVID and the lockdown, and over that time, the Bathurst BT operations were deemed an essential service by the government. In my submission, demonstrating the essential service that coal still plays to the Waikato district and those industries that the coal serves. At paragraph 9 to 20 of my legal submissions, I've gone over the statutory context here, which I won't reread, other than to the key aspect I'd like to draw the panel's attention to is the Waikato Regional Policy Statement, which obviously the district plan needs to give effect to. And in my submission, there's currently a gap there where it's not being given effect to. Policy 6.8 of the RPS identifies that there is a potential for subdivision use and development on the access to mineral resources, which include coal resources. And the RPS has a implementation method at 6.8.1 to address that, being the mapping of significant mineral resources with a list of criteria as to what will make those resources significant. And the RPS provides for that to be included in district plans, but also provides a method where if the mapping hasn't been done, the list of matters that will make a coal resource, or a mineral resource, sorry, in this case coal, significant, should still be used to determine the location and significance of that resource. So that's 6.8.1 of the RPS. And one tool the RPS requires to be used as a method for managing these effects is the management of sensitive activities around and near significant mineral resources. So that's the only statutory component I propose to bring your attention to. If I could move now to the two key themes of relief. The first being the ongoing operation and expansion of existing mining. And these operations are also referred to throughout the various reports and documents as lawfully established activities. And the method that the district plan proposes to use to provide for this are coal mine policy areas. And you'll see on Annexure E, which is on the screen, the annexure to Mr. Pilcher's evidence, the operative plan has a similar policy area, which is the horizontal blue hatching. One issue for Bathurst is it doesn't align with the proposed district plan coal policy area, which is the vertical hatching. So an example is up at the Maramarua mine, at the top of the page. There's some red areas shown, which are the currently lawfully established mining activities. These have a mining permit and a resource consent to operate. And in the middle there's no proposed district plan coal policy area shown. So Mr. Fletcher, if you could just go up the page a little bit to the top. Yeah, and just under the word Maramarua, you'll see there's the red operational mining area, and the issue being that the proposed district plan doesn't include the coal policy area within that. Now, no issue with the operative plan. It generously provides for the Maramarua mine and some area around that.
And what's the horizontal line now? What is that?
So the horizontal line is the operative district plan coal mine policy area. So that's how that's the identification of the coal policy area within the current district plan.
Yeah.
And then the vertical line, which in some places overlaps, is the proposed coal policy area.
So why was it different from the operative plan?
It's a good question. There seems to be a bit of a gap in terms of where this mapping's come from. It looks like the mapping to the operative plan has applied some coal mining licenses from Maramarua, but hasn't included all the lawfully established mining activity, potentially because it's a mining permit in the middle there. With a resource consent overlaid, but we haven't been able to track through that difference in position. As I say, in my submission, this is a point that I would expect can be relatively easily solved through some collaboration around mapping. So that's the first theme of the Bathurst relief. Yeah. In my legal submissions, I've gone into a bit of detail on describing the different rights, mining rights, because they are important to the interpretation of lawfully established activity. But in a very high level summary, we're dealing here with coal mining licenses, which are a relatively historic right under the Coal Mines Act, and they, in short, are the equivalent of a mining right under the Crown Minerals Act and a land use consent from a district council put together. And those rights continue through to today. The more modern since 1991 approach has been to separate out mining rights under the Crown Minerals Act, called mining permits, and require district council consents and obviously regional council consents for regional matters such as water, vegetation as well. So essentially, in terms of this first theme of relief, Bathurst are just seeking the mapping to give effect to those lawfully established activities. And my informal discussions with Mr. Cleese and my review of his rebuttal indicates that that's potentially a common goal from the council as well.
All right.
So the second theme of relief, there's more of a gap in the position between council and Bathurst now. I'd summarise this at 46 to 67 of my legal submissions, and this relates to the yellow shading on Annexure E. In my submission, the RPS doesn't only require the identification of these lawfully established operations, but also the protecting of the mineral resource itself through mapping. In my submission, that's something that whilst the policy framework in the proposed plan signals that at a method and mapping level that hasn't transpired, the yellow shading is the government-led mapping of the coal resource as recently as 2019. In our submission, this would comply with the RPS's definition of what's a significant coal resource. So we've overlaid that onto the plan. Obviously, this is focused on the Bathurst BT interests in the Waikato. There are others beyond the scope of our submission. But the submission for Bathurst BT is that these areas should be included in the district plan and using the tool already proposed, which is an extractive resource area, which is a tool, as I understand it, that's developed through the PDP process from the aggregate resource area, which was a similar tool applying to aggregate rather than coal. So we appreciate that these yellow areas are large, and it's fair to say that there would be potential for these to be refined, and that Bathurst BT certainly have no interest in mining these wider yellow areas in their entirety. But we've included them for now for consistency, and that these are the mapped coal resources of this area that in our submission, the RPS requires be recorded in the district plan.
If we were to put those in, what does it translate to on the ground in terms of what activities can be permitted? It's obviously, it covers privately owned land, not land owned by Bathurst. So what is does it put a freeze on anything that can be done on that land? Could you briefly describe that?
Yes, sure. So it has, at a high level, from my interpretation, two outcomes. At a policy level, it's proposed policy 5.4.2. It puts the teeth into the identification of the potential extractive resource area, which is a policy under the objective 5.4.1, which is the enabling policy for these sorts of activities. In terms of activity status, my understanding is that the coal mining policy area, which is the blue, more operational focused area, would require in those areas mining as a restricted discretionary activity, and the same would apply to these extractive resource areas. The other key tool from my interpretation of within these yellow extractive resource areas, these coal identification areas, is a significant setback requirement. And I entirely appreciate the challenges of a very restrictive setback requirement on such a large area of land, the majority of which isn't owned or controlled by Bathurst. So at the moment, there's not an easy answer. There is more work required in my submission to make these coal identification areas function in a fair way. And that could be done in two ways, either refining them down so they affect less land, or proposing a different treatment of activities within these areas. For example, it may be that these coal resource areas have some policy recognition within the district plan, but don't have the equivalent enablement as the coal mining areas, which are more progressed in terms of their being lawfully established activities. So Bathurst has used the mechanisms available within the plan, these two different mechanisms, but there is a challenge in that the two mechanisms have very similar methods, which does create the issue, which I think, Commissioner Cooney, you're touching on.
Okay, thank you.
So moving now to the final portion of the submissions, there were some components from Chapter 1 of the PDP that the panel kindly have allowed Bathurst to provide legal submissions and evidence on at this hearing, and I've summarised that at the end of my legal submissions. We've just identified the relief we're seeking there, and it's some amendments to the introduction chapter of the district plan to just amend the focus, which as notified states that coal is a difficult and challenging industry for the district, and we've made some suggestions to amend that through the relief in the submission to better acknowledge the role that I've already outlined coal plays in the Waikato and the need for that into the future, obviously not forever, but certainly for the life of this district plan. So that's expanded on further in my submissions, and I don't propose to talk more to that today.
Thank you.
The last part of the Bathurst submission, and it really should come first because it's what starts the mining process, is exploration and prospecting. Currently, the proposed district plan, doesn't provide a different method for managing exploration and prospecting versus mining in general. In our submission, the district plan could be more refined and targeted, with a permitted activity status for low impact exploration and prospecting, and we've proposed some relief at the rear of the legal submissions in relation to that, and then with a restricted discretionary activity status for exploration and prospecting that doesn't meet those permitted activities standards. And I've outlined that just at the conclusion of my legal submissions. So it's a more refined approach, and in my submission is a more appropriate way to manage those modest and low impact exploration and prospecting activities.
Okay, thank you.
So that's a very high level summary of the submissions. I appreciate there will be maybe questions. Happy to take those now, and or at the same time of any questions you may have for Mr. Pilcher on his evidence.
I think we'll leave the questions till at the end of the evidence. Thank you.
So Mr. Pilcher's evidence is relatively short, so we haven't proposed he read anything out or provide you with a further summary. So his evidence is what it is, and he's happy to take questions as well.
All right. Welcome, Mr. Pilcher. Sorry. Okay. Mr. Leakey, who else are you calling by way of evidence?
Just Mr. Pilcher. today,
Right.
sir. Yeah, so I've got Alison Brown's on the line as General Counsel, observing, happy to take questions as well. But yes, just Mr. Pilcher's evidence today.
All right. So, Mr. Pilcher, do you want to say anything at all? We've read your evidence.
Yeah, look, firstly, thank you for the opportunity to present at the hearing. I won't regurgitate a lot of what Josh said, but the importance of coal mining in the Waikato is large. Now, in the plan, it talks about the declining coal mining status. So currently, we supply at least 150,000 tonnes of coal to the Huntly Power Station, which in turn burns up to 800,000 tonnes of coal per annum. The points we'd like to make on that is that within New Zealand, through our statutory framework, environmental emissions are captured by the ETS policy and redeemed to the government, whereas overseas coal is not. There's no ETS on that, and their environmental practices are a lot lower. Plus the fact that there's far more emissions by the coal being imported through shipping and transporting and trucking to both New Zealand Steel and Huntly Power Station. The other things I'd like to reiterate is that these projects were set up to use Waikato coal, more namely the Rotorua coal. And if you look at the New Zealand Steel plant, we supply about 350,000 tonnes of coal to 400,000 tonnes of coal to that. They also import another 450,000 tonnes of coal. But because this plant was set up to burn our coal, it's essential that they do have a reasonable proportion of our coal, because if they don't, it alters the reduction process they use at that site. So for us and the Waikato region and indeed the New Zealand economy, it is actually important that coal is still used in those sites. Plus, we fully accept that thermal coal will transition to other fuel sources when they become available, whatever they may be, because currently there's talk of biomass and so forth. And what that means is there's not enough trees grown in New Zealand for that to be sustainable. And in fact, the cost of that, because you need 3 times as much product to replace coal. But we do fully accept that in 10, 20, 30 years' time, thermal coal will reduce and may not be used. However, at the current time, there is no economic or reliable alternative, and especially for the Huntly Power Station, due to droughts, that is still required, and of course for New Zealand Steel, while they're in business, they still need our Rotorua coal. The overlay on Annexure E is very, very important for us, because the proposed plan does not include our operational areas or our areas to expand into. So as Joshua said, it is absolutely important we at least have the existing operational plan areas. If you looked at that at Rotorua, there's a lot of area, including Puki coal and so forth, that aren't included, and of course at Maramarua as well. And of course the last area is, as Joshua said, is the exploration of areas that we look to plan in the future. Most other district plans that we operate under, including the South Island and the West Coast plans, most of the exploration is a permitted activity, and it's very, very low level, includes drilling and trenching, and that is absolutely essential because it takes 5 to 10 years to get a coal mine from the initial planning stage into production. And without that, we are hamstrung. So those are the main points that I wanted to raise. Happy to take any questions. I mean, you've seen in my evidence how many staff we employ, the economic contribution, but the point is that it's a national contribution as well, not just the Waikato region.
All right. Thank you. Thanks very much. Any questions, Mr. Malik?
No, nothing from me. Thank you.
Mr. Gibb.
Yes, just some clarity, please, Mr. Poulter. So on your evidence, point 34, is that where we can find there where you've got licenses for the exploration permit and the mining permits? It looks to me like is that a bit wider than what is in the proposed district plan?
Yes.
Is that more? It is.
It is, yes. Yeah.
So your submission is that you want at least what you've got permits for?
Yes, because that otherwise it hamstrings us for future expansion. Yes.
I understood that point. I just wanted to make sure I had the right map. Thanks
Correct.
very much.
Yes, thank you.
Okay.
Mr. Fulton?
Yes, just one question. At point 38 on your evidence, you talk about there's a grant for 40 years period from the 1st of April 1987. That's getting close to its conclusion. How much coal is left there, or will you complete that by the end of its licensing period?
No, so we still have significant resources. So currently at the moment, what we've got contracted will be exhausted in February 2024. However, we have some other projects planned that'll take us at least 15 years out. And but they, as you correctly point out, some of those are out of the coal mining licence, and we have a coal mining permit to cover some of those areas now. And of course, we will apply for additional coal mining permits. And of course, because it's not a coal mining licence, that will include district and regional council resource consents.
Thank you.
The coal mining licences are all very historic, and they all expire at the same time.
Can I possibly jump into, the other thing is, even when the license area or the license has expired, we have significant infrastructure on that land, which will still be needed to process coal mined in adjacent areas. So the need to recognise what is on the ground doesn't go away post 2027.
Thank you.
Thank you. Good. That's all, Mr. Kennedy. Thank you.
Okay, thank you. And just, Mr. Pilcher, one of the things I'm pretty familiar with mineral prospecting in the Coromandel and the exploration permits and prospecting. And is it the same for coal mining? It was simply bringing in a drill rig with a drill on it. Is it, or do you need to dig out areas or what?
Well, there's various stages of exploration, but you are correct. The main exploration tools we use are what we might call trenching, which is only an excavator digs down the length of its arm, which is generally 5 metres. And because of that, they look at the soil horizons and can understand a lot from that. But the main exploration is the drill rig, and which generally drills a 100 millimetre or can be 125 millimetre diameter hole. At various depths, we generally only drill down to a maximum of 100 metres because it's uneconomic to open cast mine any deeper than that. And then we discover the resource, we map that out with the geologists and so forth. So you are correct.
So it's a drill rig, it's a truck coming onto the property and drilling with a drill rig.
Or even smaller. A lot of them are tracked rigs, which are much more compact than a truck.
Okay.
Yes.
Okay.
Very low impact.
All right. Well, thanks very much for your presentation there, Mr. Leckie and Mr. Pilcher and Ms. Brown. So thank you. I haven't got any more questions.
Thank you very much, Commissioner.
Right.
It was timely. I've just rejoined right at the right moment. Thank you, everybody. We're now due to hear from the Poultry Industry Association, please.
Right. Good morning, everyone.
Morning.
I want to really just focus on the issues that concern us coming out of the rebuttal. and I understand that the panel's already heard from mainland this week, so you'll be familiar with some of the issues of concern. The poultry industry got together in this combined submission that CPI's put in together in a reasonably unusual way, actually, in that you've got 3 competing firms plus the Egg Producers Federation all putting in a joint submission. And what that process is trying to do is achieve a bit more flexibility in the district plan to recognise that the poultry industry is significant in the Waikato. And what we were wanting to do was to identify where poultry farming could be provided for as a permitted activity given certain performance standards were met. And on the basis that it's farming and that it happens in the rural zone, and that it actually can be managed without there being adverse effects on other neighbours. So that was kind of where we started from, and obviously our submission is one that proposes an ideal. And the submission identifies, and I think this process has identified, that it's actually reasonably complex industry. You've got egg producing layer farms that are both indoor and outdoor. You've got meat chicken farms that can be indoor and outdoor. You've got hatcheries and you've got breeder farms. And all of those operations have a different scale, or can have a different scale, and can give rise to different effects. And what we wanted was some recognition in the district plan of those different effects for the different types of activity. And we're pleased to see that there's been a lot of proposed change recommended, which goes a long way towards achieving what we're after, and that's good. But often the problem comes down to the detail and how it's interpreted. The original report said, the section 42A report in relation to hatcheries and breeder farms said, well, you know, and free range, give us more information. And so we've tried to provide you with just very focused evidence that identifies the details that were sought. And in terms of hatcheries and breeder farms, what we sought was, and have hopefully provided that you've seen, is the correspondence from David Stagg from Waikato Regional Council, confirming that the Regional Council doesn't consider that there are any odour or dust issues in relation to either a hatchery or a breeder farm, and they don't even get a resource consent. And what we're wanting is for the district to also recognise that the breeder farms and the hatcheries are a different kind of entity. They don't have odour and dust effects, and they should be managed purely on the basis of site coverage in the district plan. So that's the first kind of proposal in respect of those. The other types of farms, we urge the district council to be managing the effects that are relevant to the district where inappropriate setbacks are not met. Sorry, where appropriate setbacks are not met. And a frustration for the industry is that with very large boundary setbacks, you end up having, or even with the smaller setbacks actually, you end up having both regional council and district council hearings on the same stuff with different council officers there and often different council there. And then sometimes the expert witnesses are shared and sometimes they're not. And it is a duplication because for every poultry farm that is not a breeder or a hatchery, you're going to have to get a resource consent from the regional council. So what we were suggesting is that if the district council imposed a reasonable setback from both the boundary and from the closest neighbouring sensitive receptor, then it could be for free range, a permitted activity, and for meat chickens that are barn raised, indoor housed operations, and you'll have to excuse me because the industry does have this sort of rolling terminology as to how things tend to get termed. So free range tends to be consistent, but everything outside of free range, the terminology can change. But the non-free range, we were suggesting the 100-metre setback to make it a restricted discretionary, and provided again that you've got your setback from your sensitive receptor. Now, the response has recognised that free range activities have fewer adverse effects, and I think there's been an attempt to try and exclude them from the catch-all rule that would catch all the rest of the industry. And there's a new definition of intensive farming, and the problem with that is that it captures all of the low intensity free range farming, which I think was what was intended wouldn't happen, and it doesn't capture the rest. And anything that's not captured seems to be non-complying because there's no other rule that allows for permitted poultry farming. And we proposed a rule whereby free range would be permitted if there was a vegetated range area provided and you had the 100-metre setback from the boundary to the edge of the sheds. And that approach in our submission is still appropriate. The visual effects, traffic effects, those can be managed within, well, there won't be any traffic effects because what you find with poultry farms is that things such as traffic effects are no different from any other farming activity. They have vehicles coming for feed and coming backwards and forwards. They don't have a milk tanker every day, but they do have trucks collecting eggs or collecting chickens. But with that setback, you can ensure that visual effects are dealt with, and any amenity effects of having the sheds close to the fence are dealt with, and the other effects in relation to odour and dust will still be dealt with in a resource consent to the Regional Council. Most meat chicken free-range farms, they have a mown range. And the meat chickens are gone in 35, 38 to 46 days. So most of the time, for the first, I understand, about 8 days of their life, or it might even be more, they don't go outside because they're too little and they'd be too cold out there. So really, they're only out on the range for a couple of weeks, and then they've gone to the processing plant. So they are different from the big layer farms where you have big chickens that are living outside. The meat chicken free range poultry, they're young and they're predominantly little until they go off. And they're not wrecking the range area. The range area needs to get mown. The other poultry, the poultry that lives inside, we accept, again, if there's a setback, it should be a restricted discretionary activity, and then you can have criteria that the district plan considers. At the moment, the rule is proposing 300 metres from the boundary to the closest shed. Now, the report writer says that there's 34 meat chicken farms in the Waikato, so therefore it can't be too hard to get a consent. And what we've tried to do in our evidence is demonstrate that the size of farm that 300 metres means. And actually most meat chicken farms are between about 2 and 5 hectares. At least half of the ones in Waikato district are in Franklin, possibly more. And in Franklin, there was a 12-metre setback from the nearest point of a building housing animals. So I don't think it's fair to look at the Waikato rules. The flexibility we were wanting, the reduction in setback that we were wanting in Waikato, is to reflect the fact that there aren't as many farms there as there are in some of the other districts, because the rules are harder. And keeping in mind that the Regional Council can manage odour effects. That 300-metre setback, the way the rule reads, so if you're a free-range farm that's caught by that intensive farming rule, you're having to have it measured from the edge of your range area. So for a start, that's unreasonable. Why would birds being outside have any more effects than sheep or cows or horses or any other kind of stock that's outside? And it is also unreasonable in the size of the farm that you're requiring, and it just doesn't reflect the actual sizes that we're seeing in the district. What I'd like to suggest, because I think there is a general willingness that's been suggested in the Section 42A report to move towards recognising this, is given that we have got the combined industry submission plus mainland, who is part of PNs anyway. So, and Michael can speak about the relationship of all of these groups. But what I would like to suggest is that the combined groups and mainland as other poultry submitters has an opportunity to sit down again with the report writer and see if we can get a set of rules that will largely work and give effect to the sorts of concerns that the district council is raising, and then come back to you with those. Essentially have another go.
We'll keep our options open on that. We haven't heard any response to your submissions from the staff, and we will do that before we adjourn today. I mean, it's always the case that it's unhelpful to us that we have hearings and everyone says, oh, well, we think we can work this out, but haven't. We would much prefer for that engagement to have happened before now, so that we have a set of provisions in front of us that we can rely on. But we'll see where we get to at the end of the day. And if that's an appropriate course of action, we're not opposed to it, obviously. But we're also here to have a hearing and make decisions. So we're not going to adjourn things sine die so that people can, continue to engage where it's not helpful to us. But we'll see where we go.
Thank you, Commissioner, and I appreciate what you're saying about that. But this is a good example of where the devil is in the detail, and because the industry is quite a specific industry, it is quite hard to identify the problems, as has turned out in this case, with a proposed rule without having that direct liaison with the industry. But I'll let Mr. Brooks make any comment that he wants.
Thank you, Mr. Chairman, if I may. Look, firstly, in terms of the submission, first comment I'd make is you note the size, the importance of the Waikato district for the poultry industry nationally. I estimate it's at least 18% of the whole national industry. So that makes it a very big and important player. Its location between the triangle of Auckland, Hamilton, Tauranga is another key feature. I'd follow up from the comments that Dr. Horriter made in terms of we have an industry that has gone through enormous change. Firstly, particularly for the egg industry, where the Layer Code of Welfare in 2012 put a 10-year timeline on the banning of current cages. Now in 2012, 84% of all hens were in current cages. Currently that's down to 40, and by the end of 2022, all out of cages. And then a supermarket policy decision 2 years ago has meant that colony cages, they will no longer accept eggs from there. Now that means that the whole nature of that industry has changed from, or will change from, pretty much a indoor cage system to barn and free range. So a phenomenal change on an industry. And when you're talking of up to $1 million a farm for a minimum for a change from current cage just to colony, let alone to free range, etc., huge change on the lay hen industry. I would say that probably no agriculture industry in New Zealand has had to deal with the amount of change that the egg industry has had and will have from the years from 2012. And so that's an important element. So issues of certainty around resource management are critical. And you're seeing not the same level of change, but certainly the move from barn house systems for meat chickens to free range there as well. So that's growing. So those are a couple of issues. I'd strongly support the concept that Dr. Forrest has put forward of a meeting. I think for those reasons, and talking to your staff, just understanding the level of change and the necessity to get things right is really important. And we would really appreciate the opportunity to do so. So look, those are my comments. I'm happy to take any questions.
Thank you very much. Is that, I'll just pass that back to Dr. Forrest. Is that all you wish to say to us today, Dr. Forrest?
Yes, thank you, Commissioner.
Thank you. Let's just see if there's any questions. Mr. Fulton?
Thank you. Yes, I suppose my first comment would be to say that I'm very, very pleased to see that the industry has got itself together and over a non-competitive environment to try and sort this out with the council, because I think it's essential that that happens. And also just reflecting on the comments made in the main yesterday by Mainland Poultry and the change to the industry as we've just had described. The free range is a word that gets banded pretty freely, and I'm not so sure that the majority of the public understand that free range is well understood from the fact that when the birds are outside, they're really not getting any nutritional value, and all that is done in the shed. So it is a intensive farming from that perspective, that all the feedlots are always inside. But yeah, it just I think it's just good. Probably not so much in the way of a question that I'm making these comments, but I'm interested in seeing this developing and understanding all the issues that we've had in the past with poultry industry. But yeah, I think there will be progress made. So thank you. It's just really comment more than a question. Thank you.
Can I just respond on that issue of nutrition being inside? If you have it outside, of course, you have an issue of attracting pests and others. So there's this, you know, that's the desire to have the nutrition inside rather than outside.
Yeah, understood that.
Mr. Brooks, did you also want to say anything about, we did try and canvass some growers about the extent to which they'd had issues raised regarding problems with neighbours and so forth, complaints. And you will have also seen on the email that Mr. Stagg sent through that from the regional council's perspective, the majority of complaints they're getting is actually from litter spreading on farms, which are often not poultry farms. They'll be on neighbouring dairy farms where they're spreading the litter. But Michael, is there anything you wanted to say about the sort of questions you asked?
Yeah, so look, there are two things. A few years ago, as a combined industry, we did have a survey undertaken across the country looking at complaints over the last 10 years from every council. And we found, contrary, I guess, to public perception, a very low level of complaint about odour. There was an element, and I guess it always happens in all these sorts of areas, of sometimes relationship breakdowns between neighbours, and so that sometimes led to complaints on when one or either a party moves away, that the complaints went away. We also, as a lead up to this hearing, made inquiries, and look, I got feedback of about 5 or 6 complaints over recent years from all these farms on odour issues. So, I mean, certainly for the larger operations, people mightn't realise just how computer controlled the environment is, both in larger layer and certainly in all meat chicken operations. The temperature, water, feed, ventilation, airflow, it's all controlled by computer. It's overseen, can actually be overseen by a centralised set up run by the companies for the meat chicken operations. And so those environmental factors are extraordinarily well controlled in the modern poultry industry. Just on the other issue, Mainland is a part of the Egg Producers Federation, but you may be aware that Mainland are looking to or are establishing a large operation in this district. They're putting in a very large-scale barn operation. They're moving a number of birds from an operation they have in Takanini in South Auckland, moving it out of a current cage scenario into a barn operation there. And they've had some pretty long and detailed processes to get that set up. So they were, as well as knowing about the, and participating in the industry submission, and indeed the CEO of Mainland is the chairman of the Egg Producers Federation. They also wish to put in their company submission because of the very high level of investment as a company that they're putting in. So that just gives you a background of that relationship.
Thank you. Mr. Mark?
Nothing from me, thanks.
Ms. Gibb?
No, nothing from me, thank you.
Mr. Cooney?
Yeah, just Mr. Brooks, just on the complaints from neighbours, and I know odour's always one that's debated sometimes. What about things like flies? Is that a problem? I was involved years ago with one that was really a problem.
Yeah, that can be a problem in the case of poor stockmanship and poor farming. So it's not a generic problem, but if there is an issue where poor farming or practices are taking place, it can be. It's pretty rare, and generally we would get in. If we're having a hearing of an issue like that, we would do what we can to assist. Our office is a relatively small one, but one of my colleagues is a full-time, is a qualified veterinarian, and we can call on a range of resources to assist in terms of that. So yes, there has been the occasions of that, but generally we can put situations in place to address that because we see it as important for the industry as a whole. We don't want that sort of practice or situation arising. It does damage to the industry image.
Okay, and is lighting also glare? Lighting glare, is that an issue?
No. So in terms of lighting, the poultry meat code requires 8 hours of darkness, as does the layer code. So you're not going to be having that outdoor. You don't have outdoor lighting, and so you're not going to have that level of lighting. Okay. And currently in New Zealand, sheds are generally not with windows, so you're not even seeing that scenario of light.
Okay. Any other effects that I've mentioned just a few. Any others that have been the subject of complaints?
No, I guess, as I say, the odour one, and as I say, that major study we did showed that to be more of a perception issue than even we had understood. And
is there a distinction when odour is an issue? Is it more prevalent with hatcheries, or what was the other categories? Egg producing, meat, poultry farms, hatcheries, breeding farms?
No, there has been a bit more about meat producing. And look, a part of that could arise from the flow-through ventilation systems, but generally if a farm's, I think it's important to understand, a meat chicken farm, the farmers don't actually own the birds. The companies to which they are contracted own the birds. The farmers own the farm, they own the shed, they own the equipment, and then the company supplies the birds, the feed, the veterinary expertise, the livestock management expertise through farm advisors. So there's a lot of oversight from the companies. If a company is having problems from that perspective, there will be company resources offered to assist them in terms of that. So if there is going to be a problem, it's generally, everyone sees it as important to get on top of that. From a layer perspective, you don't hear of that so much, of course, in the big layer intensive systems. If you have a shed of 5,000 birds in a layer operation, it's commercially viable to have moving belts underneath the nest, so the feces is taken away. Same with the ventilation and computer control. So, a lot of environmental controls are going on, and you can actually do something if, for whatever reason, there is some breakdown or problem there. So,
Okay.
as I say, we have found that while the perception is widespread, reality is less so.
Okay, thank you.
Thank you.
Ms. Gibb, have you got any questions?
Sorry, no, Mr. Chair.
Thank you. I don't have any questions either, I don't think, but I just want to say a little bit more about what I alluded to before, Dr. Forrett. I mean, you've requested more time to resolve this issue, and that does put us up in a difficult position because unless I'm mistaken, and I apologise if I've got this wrong, but in terms of the information before us, there's a summary statement of highlighted bullet points about what the industry seeks with a small amount of background, and which we got on the 29th of September, and your submissions which we received on the 29th of September. We've heard a lot of evidence today that we're going to have to rely on the transcript to fully digest and understand. So as a starting point, it seems to me, without being too pointed in what I'm going to say, it's very little and very late, and it would be very helpful to us for future hearings if there is information of the sort that relates to effects. We would appreciate getting that early, and we'd also encourage you to have the conversations that you're wishing to do post this hearing in advance of it. Otherwise, we're just in the difficult position of hearing a whole raft of new information that's not before us before we commence. And I don't think I'll say any more. I'll leave it at that. But if your cooperation in the future would be appreciated. Thank you.
Thank you, Commissioner. I understand that. It's hard for submitters over topics such as this, the rural zone topic, where we don't know who's writing the report, and until the report's released. But I take your point that we can try and do that.
I mean, it's not hard to make contact with the council and say who's in charge of the rural hearing. I mean, you've been around long enough to know how to do that. So I'm not going to say any more about it, but
take your point.
But point to be made. I won't raise it again. So I don't think we have any more questions. Thank you.
Thank you.
Which brings us, thank you, Mr. Brooks. And that brings us to you again, Dr. Forrett, regarding Lochiel farmlands, please.
Yes, thank you. Lochiel, we've identified that there is a fundamental issue with the interpretation of the role, and I thank the report writer for pointing that out. But we want to be clear that how we are reading this rule is actually, or how the council's reading the rule. If we look at rule 22.2.3.1, and it's—
Hold on a minute, just hold on a minute. Let me make sure we've got that in front of us. Just—
Can we stick it up?
2.3.1. So really for us,
2.2.3.1. Okay, I've got it. But if we can, let's put the latest version, if we can, on the screen, please.
Would you like me to do that, or?
I don't mind who does it. If you can do it, Mr. Bell, that would be great. Thank you.
What document was this, Doctor, for it?
the chapter 22.2.3.1, the rule, earthworks general.
Yes, sorry, what document provided by you?
No, I'm talking about the district.
Oh.
I think if we use the rebuttal version of attached to Mr. Cleese's rebuttal, I think that's where we find it. (22.3.1). I don't think the page in the latest version, the pages. Sorry, it's not the. No, it's not that. Oh, no, it will be in there. I was looking at the consolidated set, but that's okay.
Yeah, Fletcher, it's Appendix 2 to my rebuttal.
Yeah, it's in the appendix, and it's on an unnumbered page, but.
To his rebuttal. Okay, that was it. It works general.
Just a little bit further up. A little bit further up. There, I think. That's the one.
No, that's number of dwellings within a lot.
What was the rule number you said? Sorry.
23.231.
22.2.3.
Oh, sorry, I thought you said 22.3.1.
Yep.
Yeah. Okay. That's why we were all confused. There we go.
Down. Down. There.
It's that blue bit.
Just down. Yeah.
So,
Okay, so that one and the next page. So if it can, is it possible to?
There we go, earthworks.
Oh, yeah.
Go back. There we are.
That's okay. We'll make do with that.
Okay, so that's where our confusion has arisen. Can we just scroll up just a little bit, please, so we can see both down, just P1 and P2 on the same screen? Okay. So originally it was unclear in the notified version, was unclear whether P1 was independent of P2. Now it looks like P2 is independent of P1, and if that's so, that resolves our issue on earthworks.
Okay.
Because ancillary rural earthworks covers a lot of things. So the only other issue relates to Rule 22.4.3, which is the rule dealing with subdivision, where you can't subdivide a site across a boundary containing an SNA. And what we're asking there is that if that non-compliance with that rule applies, we want it to move from non-complying up to discretionary. So in particular, where it says the boundaries of every proposed lot must not subdivide any of the following: A, significant natural areas. On many farms, particularly where rural landowners have been encouraged to protect areas of significant vegetation, if they then want to do any kind of boundary relocation or further subdivision and retain that protection, which happens within the rules anyway, that subdivision, irrespective of the size of the property, then kicks into being non-compliant. And in our submission, that's too harsh. There may be many situations where there's an outcome that would warrant such a subdivision being approved, and if the default status was discretionary, that would be more reasonable. And that's now that we're satisfied that earthworks rule is the two are independent, then that's really the only issue of concern for Lochiel.
All right, thank you.
Thank you.
You don't need to call or don't wish to call Ms. Robertson to present any of her evidence. We've read that and you've covered that off and updated the situation, correct?
It's Mr. Robinson.
Oh, Mr. Robertson, I'm sorry. I saw Kim Robertson and assumed he was a she. My apologies to him and to you.
He's sitting a long way from the camera. Mr. Robinson's the CEO of Lochiel, and the report writer's right. Lochiel is a very large farm within Waikato district, but certainly there are a lot of other farms that are also quite large and could be affected by this rule. But okay. No, Kim, there's nothing more you want to say? No.
We have taken off a significant number of significant areas. We just don't want to, we've done it off our own bat. We don't want to be negated if we want to change that.
Lochiel's actually amalgamated all of its titles, so it's kind of done what the district council has been wanting to do through the district plan, is to amalgamate large titles of land that are used for rural uses, but then having done so finds itself then essentially being penalised if it wanted to do anything in the future.
Okay, very good, thank you. Let's see if there's any questions. Ms. Gibb?
No, thank you, Mr. Chair.
Thank you. Mr. Fulton?
No, I have no questions, thank you.
Mr. Marg?
No, thank you.
Mr. Kearney?
No, thank you, that's very clear.
No, and I don't have any questions either, thank you very much. And apologies again, Mr. Robertson, I Misunderstood. My apologies.
Thank you.
Thank you. Which brings us to last but not least, Mr. Finlay, please.
Yes, morning. Well, nearly afternoon.
Just a moment.
Can you hear me okay?
We can hear you, but we can't see you. Is that are you on a, have you got a video connection or are you relying on the sound only?
Yeah, my settings were.
There we go.
Oh, there you go. No, we've got you now.
Yeah.
Just when you're ready, thank you.
Okay. Yeah, so I guess largely I just want to talk over my submission, which largely relates to 7B Lennox Lane, which is property myself and my wife own. And I suppose a lot of the points we're making are just around our use of the land. And,
could you just move a little bit closer to your microphone? Have you got a microphone on your headset or is it on your computer?
No, sorry, it's on the computer. Yeah, let me try.
Because you're sitting a little, I think you're moving in and out of range a little bit.
Is that a little bit better?
Yeah, that's good.
Okay, so just recap that last little bit was the items we raised in our submission largely relate to our use of the land and the limitations within the context that we're in, which is, to give you a bit of that context, is that we're a small rural lot, so 2.4 hectares, just under 6 acres, surrounded by a number of smaller rural lots, some of them the average sort of 5,000 square metres, on two boundaries. On another boundary we have a railway to Hautapu Dairy Factory, and on the last boundary we have a larger lot which is about 17 acres. So I guess in the context of that, I'll go through some around minor dwelling. So I raised just, we have quite a large lot. At the moment we aren't allowed to subdivide, whilst we'd like to be able to do that, and we'd like some provision, which I've also raised around that subdivision. Some of the other activities we'd like to do is have a secondary dwelling. It's sort of changed from ancillary dwelling or dependent persons dwelling to just a minor dwelling. And I guess it's just around understanding that context of, you have a building coverage that you're allowed, and there's some rules set about restricting what you can build. I don't have a clear understanding on why it has to be, I guess we say minor dwelling because it's not the main dwelling, but as far as how that building coverage is split, it's fairly restrictive. 70 square metres, I think, has been raised by a number of other submissions. It's very limiting, especially that includes garaging and other aspects of a house which aren't so useful for living in the house. So from our perspective, we'd see maybe a young couple wanting to live in a smaller house in a rural setting, and we actually had that privilege at a previous tenancy where we were, and it worked really well. But it was under the old rules, which was 70 squares plus garaging, so it was more effectively like 100 or so square metres. Anyway, in brief, I guess I sort of the limitation of 100 square metres or 70 square metres, put a number on it. I don't quite understand the outcome, how that's beneficiary, in that you restrict what people can use that house for, so you end up having more of the compromise in the build. I'm a builder myself, so it's very hard to sort of cater for, I guess, a young family. They might have a couple of kids within 70, 100 square metres, and I suppose morally the resort is that there'd be some compromise and that area would be expanded. I guess in addition to that, the building coverage itself, 500 square metres, we have, I guess, 24,000 square metres of land, of which we're only allowed to use 500 square metres for building coverage. Some simple math, 300 square metre house, 200 square metre shed, you no longer can do other activities like have a secondary dwelling. You might say, well, that's how you prioritise the land, but I guess my rebuttal to that is that next door to us we have 20,000 square metres split into 5 sections, all with 300 or 400 square metres of coverage. So I don't quite understand the thinking there and why it would be so restrictive. I guess the relief thought is that we would be allowed to have a greater coverage. I don't know how you best do that, but I guess that if that summarises that point, it sort of overly restricts what we can and how we prioritise what we build, and it affects sort of, if we have a large block that we need to use in a rural setting, we need more other infrastructure, such as barns and sheds and things like that to store equipment. The other aspect is earthworks, which I raised, but from what I looked through the rebuttal report, it looked like that had been pretty well addressed by others. So I think I'll leave it pretty shortly, other than to say the definition it was contouring and cropping and that sort of thing seemed to be excluded under the original definition. But setbacks, building setbacks. So I guess this is around, we are a larger lot than 1.6 hectares, so we can not build any closer than 25 metres to our neighbours. However, they are less than 1.6 hectares, so they can build within 12 metres. And I don't quite understand what reverse sensitivity we are having to provide for, given that we're both rural. They have buildings and our buildings within 12 metres. Are we providing an amenity to them, or can we look at reducing those setbacks where there's a smaller lot next to a rural lot that you would allow equal setbacks on either side of that boundary? I understand when you have a large lot, you might keep that rural feel or the separation there, but where you have smaller lots neighbouring a large lot, it seems that the large lot is unfairly compromised, I suppose. You force intensification in the centre of the section, depending how big it is. Ours is quite large, but ultimately, we'd like to position building, knowing that there's a desire to intensify as the city grows. So I think it allows for better future planning and positioning of buildings. I'll leave that there. So really, the relief sought there is that there at least be equal size of the boundary where the small lot on a large lot. Brings me to prohibited subdivision. So under the proposed plan, it was prohibited, I believe, for lots 40 hectares or less. In our case, what I've put forward is that it'd be nice if we could accommodate smaller lots such as ours, where we're a couple of hectares, already segmented rural land, not overly productive, and potentially if you did become more intensified, like cropping of berries and etc. like that, which might work on smaller blocks, you've actually got you've got small lot or small rural sections next door with houses that would be affected by those operations. So you're sort of caught in the middle of, or we are caught in the middle of a nice perspective of what rural should be versus perspective that might be, and it's not quite working for us, and we'd like some relief as far as either being able to repurpose our land for, ultimately we'd like to be able to subdivide. And we think that that would be in keeping with the area. How it's achieved is, I guess a different matter, but I think some allowance for those lots that are already smaller and aren't necessarily going to impact on your useful farming land, that would be beneficial. And I think in our current situation, the reverse sensitivity is already working out well. As far as we have farms next to us, we also have houses. It's not an issue. And we also have a railway on another boundary, so it's sort of reducing the effect of if we were to subdivide. It's not really much different to what we already have, which is effectively country living created in the rural zone. So I think that probably summarises my main points I'd like to make, but really it comes down to the utilisation of the land and future-proofing how we might cater for more intensification, and in our case we'd like to bring some of that forward if we can.
Right. Thank you, Ms. Finlay. Let's see if there's any questions. Ms. Gibb?
No, thank you.
Mr. Fulton?
Just understanding your position and where you are. It's a difficult area though, isn't it? I mean, effectively there's been incremental creep, if you want to say that, within your region, because people have been permitted to do various things and subdividing it into 3 and into smaller blocks. You're one of the ones left with a bigger block, which you feel now you're being a little bit penalised. Is that a comment you're making?
I don't necessarily feel I'm being penalised. We were grateful for the opportunity, but I suppose we're penalised within the framework of how we can act within the rural setting, because we're a large lot, no setbacks are larger, but also, yeah, there's no opportunity to create what's already effectively around us. So, yeah, it does seem like a landlock, I suppose.
Okay, thank you.
Mr. Marg?
No, nothing from me, thank you.
Mr. Cooney?
No, thank you.
No, and I don't have any questions either. Thanks, Mr. Finlay. That's all pretty clear. So thank you for your submission.
Okay, thank you.
Which I think brings us to the end of the submitters that have requested to be heard at this hearing. Am I correct in that assumption? There's no one else here that's expecting to present to us today? No, it appears not, so that's helpful. What we normally do at this point of the hearing is to get some reply comments from the Section 42A report writers. I'm mindful of the fact that there's been a bunch of information that we've heard today that you may have read some of before but haven't heard from before. What's the staff view on how they might exercise the reply right that we've made available?
Look, more than happy to give a verbal response today, just sort of probably fairly highlight, sort of just summarising my reflections on the evidence that we've had over the last few days. And then if the panel would like, more than happy to do a more of a fulsome sort of written response, sort of, sometime next week. But I'm certainly happy to respond verbally today to what we've heard, and likewise to sort of cover off some of the points raised this morning too. So pretty familiar with where Bathurst and the poultry farming people were coming from, so quite happy to talk to those briefly.
What about you, Ms. Overwater?
Yeah, so I agree with Jono. A verbal highlights package from me is kind of what I had in store, with the opportunity to provide some written, a written closing statement. There's a few things that I still need to probably come back to the panel on. So yeah, that would be my position at the moment.
All right, what's the...
And if I may add, I wonder if the panel are of mind to stop for lunch, perhaps for an hour now, let the council collect their thoughts and reflect on the evidence I've heard this morning, and perhaps resume at 1 o'clock as a suggestion.
Well, I was going to ask whether you needed a bit of time to gather your thoughts and so forth. So let me just check with the panel. Is the panel happy, A, with the approach of the 42A report writers giving us a verbal update, if you like, now, coming back and writing at a time that we can discuss once we've heard the verbal reply, and that we take an hour for lunch now and resume at 1 o'clock to do that? Is everyone happy with that?
Yeah.
Yes, fine with me.
Yes.
The only logistical thing we need to do is that I think this is the end of our notice of hearing that the public will be aware of. Am I right in thinking that? And I don't think it's a good idea to leave this particular link open over lunchtime and come back, although I guess we could do that.
Come back in. To my understanding, I don't think any other submitters are anticipating that we'll be returning after lunch in any case. So we could just leave this open for an hour and just resume. Yeah,
I'm always a bit loath to do that for an extended period of time like that, because you never quite know, because it is, I don't know, what do people think?
I've got no problem with it, Phil.
should we just leave it open then and
Yeah.
come back at 1 o'clock?
Didn't you send us a link for this afternoon?
Yeah, that wasn't a public. That was for us. Or maybe it did.
No, it did go out to the public as well.
Is that a public link? That one?
Okay.
Yeah, it is.
Well, I think on that basis we can come back in on that one, can't we?
Yeah, that we can do that.
Well, I think let's do that. I think that's preferable because I wouldn't mind having a quick conversation with the panel, but I don't. We'd like to do that in private, I think, rather than live on air for all to hear. So let's do that. If everyone could, that's not part of the panel, could